Hello. Okay, so tonight it is lesson number 6 on, I'm using teaching tolerance lesson plan, and we're going over the new Jim Crow. I'm going to go ahead and find this on my site, and I'm going to give you, if you go to my website, www.southernfriedsocialist.com, then you will have access to a glossary. And tonight's vocabulary has already been put on the glossary, and it's also on the blog post associated with tonight's chapter. On the comment section underneath this, I'm going to give you a link to the guided reading, and I'm also going to give you a link to the critical thinking questions. And yep, that's me. Is that lesson 6? Ooh, my hair looks bad tonight. Haha. Who cares? Who cares about hair? Okay, comment. And then let's see. Guided reading, study questions, and the link to the lesson on my blog. I'm trying to make it nice and clean for you. I guess my mother just texted me. Guess it's my birthday, and I didn't even realize it. Oops. Well, anyway. Okay, I'm going to post the essential question for tonight's chapter along with our vocabulary. And then directly after that, I am going to post the end notes so that you, my friends, have all of the access to you have access to be able to go and research all you want to research. I know that it looks really weird and it's got question marks, but I think you can basically get the gist of it. I'm just trying to make sure that people who wonder here after we've done this can kind of find themselves and find out where I'm coming from. Okay, that is all the information on tonight's chapter. We are reading The New Jim Crow by Michelle Alexander, and we are on lesson 6, and I am using Teaching Tolerance's lesson plan guide. So, lesson 6 is focused on chapter 2. I have a link on my blog to the entire chapter 2 being read by the author. So if you want to listen to the entire chapter 2, you don't have to buy the book. And then if you go back on previous lessons, when we're going over chapter 1, I always provide you with a link. These guided readings are basically, if you don't have time to read the entire chapter, or if you've only got 30 minutes to go over this is the nitty-gritty parts of the lessons and the points that are important that we need to talk about and that we need to understand. So, anyway, I'm going to go ahead and start. And what I'm going to do is I'm going to read I'm going to read 5 questions. And then I'm going to start reading. Then I'm going to pause, and I'm going to read a couple more questions. And so as I'm reading, kind of think about those. So, how does the author juxtapose, as in reverse, switch, the first 2 paragraphs of the excerpt? What might be her intention with this strategy? How does juxtaposition set the stage for the rest of the excerpt? The author argues that the war on drugs is the necessary lens for understanding mass incarceration. Cite where in the excerpt she makes this point most directly. Far more people are arrested for possessing drugs than selling them. Cite the statistical evidence that the author provides to substantiate this claim. What is your opinion on this approach to the war on drugs? The author includes lots of statistics and data in the beginning of this excerpt. Which of these do you find most compelling or important? Why do you feel this way? Which do you think would surprise most people, and why? The Fourth Amendment provides the right to privacy. Alexander argues that the war on drugs has undermined this right and other civil liberties. List 3 of the police practices she gives as examples of these violations of these rights. So that's our first 5 questions. We're going to cover that probably pretty fast over as the reading goes along. So anyway, The New Jim Crow by Michelle Alexander, Chapter 2, The Lockdown. We may think we know how the criminal justice system works. Television is overloaded with fictional dramas about police, crime, and prosecutors. Shows such as Law and Order. A charismatic police officer, investigator, or prosecutor struggles with his own demons while heroically trying to solve a horrible crime. He ultimately achieves a personal and moral victory by finding the bad guy and throwing them in jail. This is the made-for-TV version of the criminal justice system. It perpetuates the myth that the primary function of the system is to keep our streets safe and our homes secure by rooting out dangerous criminals and pursuing them. Those who have been swept within the criminal justice system know that the way the system actually works bears little resemblance to what happens on television or in movies. Full-blown trials of guilt or innocence rarely occur. Many people never even meet with an attorney. Witnesses are routinely paid and coerced by the government. Police regularly stop and search people for no reason whatsoever. Penalties for more crimes are so severe that innocent people plead guilty, accepting plea bargains to avoid harsh mandatory sentences, and children, even as young as 14, are sent to adult prisons. In this chapter, we shall see how the system of mass incarceration actually works. Our focus is the war on drugs. The reason is simple. Convictions for drug offenses are the single most important cause of the explosion in the incarceration rates in the United States. More than 31 million people have been arrested for drug offenses since the drug war began. To put the matter in perspective, consider this. There are more people in prison and jails today just for drug offenses than were incarcerated for all reasons in 1980. Nothing has contributed more to the systematic mass incarceration of people in color in the United States than the war on drugs. Before we begin our tour of the drug war, it is worthwhile to get a couple of myths out of the way. The first is that the war is aimed at ridding the nation of drug kingpins, or big-time dealers. Nothing could be further from the truth. The vast majority of those arrested are not charged with serious offenses. In 2005, for example, 4 out of 5 drug arrests were for possession, and only 1 out of 5 was for sales. Moreover, most people in state prisons for drug offenses have no history of violence or significant selling activity. The second myth is that the drug war is principally concerned with dangerous drugs. Quite to the contrary, arrests for marijuana possession, a drug less harmful than tobacco or alcohol, accounted for nearly 80% of the growth in drug arrests in the 1990s. Is that not crazy, y'all? I'm telling you what. I'm going to share this to my page real fast. Oh, where is it? La, 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 la. And then we will go right back to it. Oh, no. Yes, we will go right back to it. Post. And then, let's see. I'm going to do one more. Share to a page. Give me just 1 second. In a perfect world, I'm going to go back. Oh, there's a kitten. There's a kitten sneaking up on us. Okay, so, get out of the way. Nori. Okay. I've got like 7 cats. I've got a problem. But in my defense, my husband brings home just as much as I do. So, we begin our exploration of the drug war at the point of entry, arrest by the police, and then consider how the system of mass incarceration is constructed to reward mass drug arrest and facilitate the conviction and imprisonment of an unprecedented number of Americans, whether guilty or innocent. Not on my shirt, not on my shirt, not on my shirt, not on my shirt. This is a nice shirt. Sorry. Rules of the game. Few legal rules meaningfully constrain the police in the war on drugs. This may sound like an overstatement, but upon examination it proves accurate. The absence of significant constraints on the exercise of police discretion is a key feature of the drug war's design. It has made the roundup of millions of Americans for nonviolent drug offenses relatively easy. With only a few exceptions, the Supreme Court has seized every opportunity to facilitate the drug war, primarily by eviscerating Fourth Amendment protections against the unreasonable search and seizures by police. Most Americans do not know that the Fourth Amendment of the U.S. Constitution actually says, or what it requires of the police. It states in its entirety, the right of the people to be secure in their persons, houses, papers, and elects against and protects against unreasonable search and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the person or things to be seized. So it says they can't just search you nilly-willy. They have to have probable cause, and I do believe that's either one of today's vocabulary words or one of yesterday's vocabulary words. The right of the people to be secure. Until the war on drugs, courts had fairly stringent. Until the war on drugs, courts had been fairly stringent about enforcing the Fourth Amendment requirements. The Fourth Amendment is but one example. Virtually all constitutionally protected civil liberties, that's a vocabulary word, have been undermined by the drug war. The court has been busy in recent years approving mandatory drug testing of employees and students, upholding random searches and sweeps of public schools and students, permitting police to obtain search warrants based on an anonymous informant's tip, expanding the government's wiretapping authority, legitimizing the use of paid unidentified informants by police and prosecutors, approving the use of helicopter surveillance of homes without warrant, and allowing the forfeiture of cash, homes, and other property based on unproven allegations of illegal drug activity. So, I know that right now, this is me talking, not the text. I know that right now there's something going on about how, like, if you get pulled over for, like, if they think that you have a, for any reason, basically, they can pull you over. And if you have a certain amount of money that they deem to be suspicious, I know that they can take it, because I was going to Orange Beach one time, and one of my other friends had all their money taken by the police. It's like, some people take money on vacation. Anyway, sorry, my rant. There's also a whole lot more than that. But, there's also, remember recently how there was a school where they spent like the entire school pretty much got shut down, and they all went outside, and drug dogs went through everything and did not find anything. And like all the kids lost an entire day of schooling because of nothing. The new legal rules have ensured that anyone, virtually anywhere, for any reason, can become a target of drug law enforcement activity. Unreasonable suspicion. Once upon a time, it was generally understood that the police could not stop and search someone without a warrant unless there was probable cause to believe that the individual was engaged in criminal activity. That was the basic Fourth Amendment principle. In Terry versus Ohio, hold on. Let's do our next 5 guided reading. In Terry versus Ohio, 1968, the notion of probable cause was replaced by reasonable, articulable suspicion as sufficient justification to stop, question, and frisk a person. Explain the difference. What was U.S. Supreme Court Justice Douglas' opinion on the ruling? What's the author's, and what is your opinion? How is a police officer able to search a random person on the street? What amounts to consent in these instances? What reason does Alexander give for being suspicious of the consent given? Alexander's the author. What is a pretext search? This is important, especially in the South. I've seen it happen. Everybody in the South's seen this happen. What is a pretext search? Provide an example of how such a search might take place. Is evidence of drug or probable cause to suspect drugs necessary for consent searches and pretext searches? Explain why you think that in your evidence from the excerpt. The excerpt, the guided reading that you do have access to, and you also have access to the entire chapter at socialist.com. And this is lesson 6, the lockdown. If a highway patrol officer is quoted saying, "It's sheer numbers. You've got to kiss a lot of frogs before you find a prince." What policing technique is this man describing? Who are the frogs in this scenario? Who is the prince? What are the benefits of this approach to law enforcement? And what are its problems to civilians? So, that's our next 5 questions for the next part of the reading. Once upon a time, it was generally understood that police could not stop and search someone without a warrant unless there was probable cause to believe that an individual was engaged in criminal activity. That was the basic Fourth Amendment principle in Terry v. Ohio, decided in 1968. The Supreme Court modified that understanding, but only modestly, by ruling that if and when a police officer observes unusual conduct by someone the officer reasonably believes to be dangerous and engaged in criminal activity, the officer is entitled, for the protection of himself and others in the area, to conduct a limited search to discover weapons that might be used against the officer. Known as the stop and frisk rule, the Terry decision stands for the proposition that so long as a police officer has reasonable articulable suspicion that someone is engaged in a criminal activity and dangerous, it is constitutionally permissible to stop, question, and frisk him or her, even in the absence of probable cause. How is some kid having a joint going to kill you? How does implicit bias, which is one thing that we go over in lesson 1, play into this scenario, do you think? Think about that. Justice Douglas dissented in Terry on the grounds that granting police greater power than the magistrate judge is to take a long step down the totalitarian path. His voice was a lonely one. Most commenters at the time agreed that the cat stepped on it, and I don't know what this says. It says something power. According police, that police, the power and discretion to protect themselves during an encounter with somebody they believe to be dangerous criminal is not unreasonable under the Fourth Amendment. You know, like when you print things and it's got those like weird little boxes over, I guess, things it doesn't know what it's saying. I feel like Wheel of Fortune. It looks like abhorring police, the power, but I know that's not what it is. History suggests Justice Douglas had the better of the argument. In the years since Terry, stops, interrogations, and searches of ordinary people driving down the street, walking home from the bus stop, or riding the train have become commonplace, at least for people of color. Today, it is no longer necessary for police to have any reason to believe that people are engaged in criminal activity or actually dangerous to stop and search them, as long as you can give consent. The police can stop, interrogate, and search you for any reason or no reason at all. Poor excuse. So-called consent searches have made it possible for the police to stop and search just about anybody walking down the street for drugs. All a police officer has to do in order to conduct a baseless drug investigation is to ask to speak with someone and then get their consent to be searched. So long as orders are phrased as a question, compliance is interpreted as consent. "May I speak with you?" thunders an officer. "Will you put your arms up and stand against the wall for a search?" Because almost no one refuses, drug sweeps on the sidewalk and on the buses and trains are easy. People are easily intimidated when the police confront them, hands on their revolvers, and most have no idea the question can be answered, "No?" But what about all the people driving down the street. How do police extract consent from them? The answer is pretext stops. So, like, if you're walking, what this is saying is, like, if a cop's walking down the street and he suspects somebody, and, like, implicit bias plays into this, and they stop them and they search them, they pretty much just kind of, like, mind trick you into going along with what they're saying and consenting to something that you can legally say no to, because you have an amendment right to feel safe in your persons. So, the pretext stop is one of our words, and I'm going to go back and alter the definition to include the author's definition. But, so, if these cops have every ability to try and search anybody they want going down the sidewalk, how do they get anybody they want going down the street? Like consent searches, pretext stops are favorite tools of law enforcement in the war on drugs. A classic pretext stop in the traffic stop motivated not by any desire to enforce traffic laws, but instead motivated by a desire to hunt for drugs in the absence of any evidence of illegal drug activity. In other words, police officers use minor traffic violations as an excuse, a pretext, to search for drugs. Even though there is not a shred of evidence suggesting the motorist is violating drug laws, pretext stops, like consent searches, have received the Supreme Court's unequivocal blessing. Your taillight's out, sir. I didn't see you use your turn signal. Did you roll through that stop sign? Kissing frogs. Court cases involving drug law enforcement almost always involve guilty people. Police usually release the innocent on the street, often without a ticket, citation, or even an apology, so their stories are rarely heard in court. Hardly anyone files a complaint. For good reason. Many people, especially poor people of color, fear police harassment, retaliation, and abuse. After having your car torn apart by the police in a futile search for drugs, or being forced to lie spread eagle on the pavement while the police search you and interrogate you for no reason at all, how much confidence do you have in law enforcement? You remember how the law enforcement recently, I want to say somewhere in Texas, had some old girl pulled out of her car and her clothes torn off and gave her like a 10-minute vaginal exam trying to find drugs? I don't care what she's got in her hoo-ha. There is no call for that. We are human. That woman, I don't even care if she's somebody's sister, daughter, what. She's someone, and she deserves dignity. The inevitable result in that the people who wind up in front of a judge are usually guilty of some crime. The parade of guilty people through America's courtrooms gives the false impression to the public, as well as to judges, that when the police have a hunch, it makes sense to let them act on it. So, they pull over all these people, and all the people they don't find drugs on, they just go on about their way because they don't want to be harassed anymore. So, but then the people that they do happen to find drugs on, so that makes it look like, you got 100 people, and all your searches were illegal, and, most of 80% of them don't have anything on them, and they just leave. The judge doesn't know that you had used your implicit bias to inconvenience and break the constitutional amendment of 100 people. The truth, however, is that most people stopped and searched on the war on drugs is perfectly innocent of any crime. The police have received no training that enhances the likelihood that they will spot the drug criminals as they drive by and leave everyone else alone. To the contrary, tens of thousands of law enforcement officers have received training on guaranteeing precisely the opposite. The Drug Enforcement Agency, DEA, trains police to conduct utterly unreasonable and discriminatory stops and searches throughout the United States of America. And I live down here in Texas, and especially by the border. This is very true. In Arkansas, African Americans were harassed a lot, and anybody with out-of-state plates, especially in rural Arkansas. And then down here on the border, they are very much harassed when they are brown folks. So I've seen this personally. Perhaps the best known of these training programs is Operation Pipeline. The DEA launched Operation Pipeline in 1984 as part of the Reagan administration's rollout of the war on drugs. Officers learn, among other things, how to use minor traffic violations as a pretext to stop someone, how to lengthen a routine traffic stop and leverage it into a search for drugs, how to obtain consent from a reluctant motorist, and how to use drug-sniffing dogs to obtain probable cause. The program's success requires police to stop staggering numbers of people in shotgun fashion. This volume approach to drug enforcement sweeps up extraordinary numbers of innocent people. As one California highway police officer said, "It's sheer numbers. You've got to kiss a lot of frogs before you find a prince." Accordingly, every year, tens of thousands of motorists find themselves stopped on the side of the road, fielding questions about imaginary drug activity, and then succumbing to a request for their vehicle to be searched, sometimes torn apart, in a search for drugs. It has been estimated that 95% of pipeline stops yield no illegal drugs. The drug courier profiles utilized by the DEA and other law enforcement agencies for drug sweeps on highways, as well as in airports and train stations, are notoriously unreliable. The profile can include traveling with luggage, traveling without luggage, driving an expensive car, driving a car that needs repairs, driving with out-of-state license plates, driving a rental car, driving with mismatched occupants, acting too calm, acting too nervous, dressing casually, wearing expensive clothes or jewelry, it's like damned if you do and damned if you don't. Being one of the first to deplane, being one of the last to deplane, deplaning in the middle, paying for a ticket in cash, using large denomination currency, using small denomination currency, traveling alone, traveling with a companion, traveling with a group, and so on, even striving to obey the law fits that profile. I don't know if you noticed, how do you travel without being a part of one of those groups? Honestly, everybody. How do you travel without being one of those groups? The Supreme Court has allowed use of drug courier profiles as guides for an exercise in police discretion. Although it has indicated that the mere fact that someone fits a profile does not automatically constitute reasonable suspicion of justifying a stop, courts routinely defer to these profiles, and the court has yet to object. It pays to play. It is fair to wonder why the police would choose to arrest such an astonishing percentage of American. It is fair to wonder why the police would choose to arrest such an astonishing percentage of the American public for minor drug crimes. The fact that the police are legally allowed to engage in the wholesale roundup of nonviolent drug offenders does not answer the question, why would they choose to do so? Particularly when the most police departments have far more serious crimes to prevent and solve. Why would police prioritize drug law enforcement? Drug use and abuse is nothing new. In fact, it's been on the decline, not on the rise, when the war on drugs began. And you know what? This is awfully pertinent for right here in Texas and all those rape kits that are going around not tested and growing mold. We got $70 billion to go to war and kill a whole bunch of children and to build this stupid-ass wall. Or, I don't know, that's not the thing. I hope they don't do that. But we just literally spent $70 billion for war. And, I got sidetracked. Moving on. I'm not going to get on a rant. Ooh. Once again, the answer lies in the system design. Every system of control depends for its survival to be on the tangible and intangible benefits that are provided on those who are responsible for the system's maintenance and administration. This system is no exception. At the time of the drug war was declining, illegal drug use and abuse was not a pressing concern in most communities. The announcement of a war on drugs was therefore met with some confusion and resistance within law enforcement. Many states and local law enforcement officials were less than pleased with the attempt by the federal government to assert itself in local crime fighting, viewing the new drug war as an unwelcome distraction from more serious crimes, such as murder, rape, grand theft, and violent assault. all of which were of far greater concern to most communities than the illegal drug use. The resistance within law enforcement to the drug war created something of a dilemma for the Reagan administration. In order for the war to actually work, the drug war, that is, it needed to succeed in achieving its political goals. It was necessary to build a consensus among state and local law enforcement agencies that the drug war should be top priority in their hometowns. The solution? Cash. Huge cash grants were made to those law enforcement agencies that were willing to make drug law enforcement a top priority. In 1988, at the behest of the Reagan administration, Congress revised the program that provides federal aid to law enforcement, renaming it the Edward Bryan, Bryan Memorial State and Local Law Enforcement Assistance Program, after the New York City police officer who was shot to death while guarding the home of a drug case witness. The Bryan program was designed to encourage every federal grant recipient, to help fight the war on drugs. Millions of dollars in federal aid have been offered to state and local law enforcement agencies willingly to wage the war. By the late 1990s, the overwhelming majority of state and local police forces in the country had availed themselves of the newly available resources and added a significant military component to buttress their drug war operations. So, the Reagan administration wanted to. The war on drugs was not a big issue. Like, it just really wasn't. So they made it one. And they did it by using cash as an incentive to local police stations and law enforcement agencies. Waging war. In barely a decade, the war on drugs went from being a political slogan to an actual war. Now that police departments were suddenly flush with cash and military equipment earmarked for the drug war, they needed to make use of their new resources. Paramilitary units, most commonly called Special Weapons and Tactics or SWAT teams, were quickly formed in virtually every major city to fight the drug war. Today, the most common use of SWAT teams is to serve narcotics warrants, usually with forced, unannounced entry into the home. In fact, in some jurisdictions, drug warrants are served only by SWAT teams, regardless of the nature of the alleged drug crime. Drug raids conducted by SWAT teams are not political encounters. In countless situations in which police can easily have arrested someone or conducted a search without military-style raid, police blast into people's homes, typically in the middle of the night, throwing grenades, shouting, and pointing guns and rifles at anyone inside, often including young children. In recent years, dozens of people have been killed by police in the course of these raids, including elderly grandparents and those who are completely innocent of any crime. SWAT raids have not been limited to homes, apartment buildings, or public housing projects. Public high schools have been invaded by SWAT teams in a search for drugs. In November 2003, an example, police raided Stratford High School in Goose Creek, South Carolina. The raid was recorded by the school's surveillance cameras as well as police cameras. The tape showed students as young as 14 being forced to the ground in handcuffs as officers in SWAT team uniforms and bulletproof vests aimed guns at their head and let a drug sniffing dog tear through their backpacks. That is ridiculous. The raid was initiated by the school's principal, who was suspicious that a single student might be dealing marijuana. No drugs or weapons were found during the raid, and no charges were filed. Nearly all the students searched were seized. Nearly all of the students who were searched and seized were students of color. Finders keepers. As if the free military equipment, training, and cash grants were not enough, the Reagan administration provided law enforcement with yet another financial incentive to devote extraordinary resources to drug law enforcement. Rather than more serious crimes, state and local law enforcement agencies were granted the authority to keep for their own use the vast majority of cash and assets they seized when waging the drug war. This dramatic change in policy gave state and local police an enormous stake in on the war on drugs, not in its success, but in its perpetual existence. If you seized that boat, because you found some crack on it, you get that boat. What about that nice truck? What about that house? Or that piece of land? Can we seize that? surely there's got to be a loophole. Suddenly, police departments were capable of increasing the size of their budgets quite substantially, simply by taking the cash, cars, and homes of the people. Shh! Dakota, please. Sorry, I got pups. Suddenly, police departments were capable of increasing the size of their budgets quite substantially, simply by taking the cash, cars, and homes of people suspected of drug use or sales, because those who were targeted were typically poor or of moderate means. They often lacked the resources to hire an attorney or pay the considerable court costs. As a result, most people who had their cash or property seized did not challenge the government's action, especially because the government could retaliate in filing criminal charges, baseless or not. That seems like threatening. Just saying. Time served. Once convicted of felony drug charges, one's chances of being released from the system in short order are slim. At best, the elimination of judicial discretion through mandatory sentencing laws has forced judges to impose sentencing for drug crimes that are often longer than most violent criminals receive. When judges have discretion, they may consider a defendant's background and impose lighter penalty if the defendant's personal circumstances, extreme poverty, or experience of abuse, for example, warrant it. This flexibility, which is important in all criminal cases, is especially important in drug cases, as studies have indicated that many drug defendants are using or selling to support an addiction. Referring a defendant to a treatment rather than sending him or her to prison may well be the most prudent choice, saving government resources and potentially saving the defendant from a lifetime of addiction. Likewise, imposing a short prison sentence or none at all may increase the chances that the defendant will experience successful re-entry into society. A lengthy prison term may increase the odds that re-entry will be extremely difficult, leading to relapse and re-imprisonment. In Harmelin, Harmelin, Harmelin versus Michigan, the court upheld a sentence of life imprisonment for a defendant with no prior convictions who attempted to sell 672 grams, approximately 23 ounces of crack cocaine. This ruling was remarkable given that prior to the Drug Reform Act of 1986, the longest sentence Congress had ever imposed for possession of any drug in the amount was 1 year. A life sentence for a first-time drug offense was unheard of in the rest of the developed world. Wow. Well, just since 1986, we've been conditioned by our society to think that somebody that just has some crack cocaine should spend the rest of their life in jail. Like, Johnny Depp has probably had more than 672 grams of crack cocaine on him at a time, or at least in his car, and everybody would still fall all over him if they saw him. Like, okay. Moving on. And plus, like, a lifetime sentence for a first-time drug offense was unheard of in the rest of the developed world. Oh, prior to 1986. Wow. Mandatory sentencing laws are frequently justified as necessary to keep violent criminals off the street. Yet those penalties are imposed most often against drug offenders and those who are guilty of nonviolent crimes. In fact, under the three strikes regime in California, a repeat offender would be someone who had only a single prior case decades ago, and one arrest can result in multiple strikes. For example, imagine a young man, 18 years old, who is arrested as part of an undercover operation and charged with 2 counts of dealing cocaine to minors. He had been selling to friends to earn extra money for shoes and basic things his mother could not afford. The prosecutor offers him probation if he agrees to plead guilty to both charges and to snitch on a bigger dealer. Terrified of doing prison time, he takes the deal. Several years later, he finds his punishment will never end. Branded a felon, he is struggling to survive and to support his children. One night, he burglarizes a corner store and steals food, toothpaste, Pepsi, and diapers for his baby boy. He is arrested almost immediately a few blocks away. That's it for him. He now has 3 strikes. His burglary can be charged as a 3rd strike because of his 2 prior felony convictions, and he is eligible for life imprisonment, and his children will be raised without a father. The prison label. Once a person is labeled a felon, he or she is ushered into a parallel universe in which discrimination, stigma, and exclusion are perfectly legal, and privileges of citizenship such as voting and jury services are off limits. It does not matter whether you matter whether you spent time in prison. Your second-class citizenship begins the moment you are branded a felon. Most people branded felons, in fact, are not sentenced to prison. As of 2008, there were approximately 2.3 million people in prisons and jails, and a staggering 5.1 million people under community correctional supervision, i.e. probation or parole. Those are terms that if you don't understand what they mean, they're on the blog, and all new terms are added to my glossary. For those released on probation or parole, the risks are especially high. They are subject to regular surveillance and monitoring by the police, and may be stopped and searched, with or without their consent, for any reason or for no reason at all. As a result, there are far many more likely to be arrested, again, than those whose behavior is not subject to constant scrutiny by law enforcement. The extraordinary increase in prison admissions due to parole and probation violations is due almost entirely to the war on drugs. With respect to parole, in 1980, only 1% of all prison admissions were parole violators. 20 years later, more than 1/3, 35%, of prison admissions resulted from parole violations. This is a side note and not me, this side note, not the text. The way I see this is just kind of like a bank making money off of everybody's overdraft charges. They just made $300,000 off of a whole bunch of people that couldn't afford it. Anyway, in this system of control, failing to cope well with one's exile status is treated like a crime. If you fail after being released from prison with a criminal record, your personal badge of inferiority, to remain drug-free, or if you fail to get a job against all the odds, that's like the check the box. So like I know that Dallas and San Antonio had voting when you go for your voting, and it was like check the box, because when you go to get a job and it's like, have you ever been convicted of a thing, that's kind of like discriminatory, because like they're not going to call you back. They're automatically going to throw out all those people who check that box due to their implicit bias, which we went over on chapter 1, and they're just going to, even though they don't know that they're going to do that, they do it anyway. It just happens because of implicit bias. So, to remain drug-free, and if you fail to get a job against all the odds, or if you get depressed and miss an appointment with your parole officer, or if you cannot afford a bus fare or a cab fare to take you there, you can be sent right back to prison, where society apparently thinks millions of Americans belong. Most ultimately return to prison, sometimes for the rest of their lives. Others are released, again, only to find themselves in precisely the circumstances they occupied before, unable to cope with the stigma of prison label and their permanent pariah status. Pariah status is a caste system. It's the lowest form of a caste system. A caste system is a societal system that works in the background of society, and it is on the blog, and there's a whole discussion on what a caste is, but a pariah is the lowest undercaste, because the prison society, and once you're labeled a felon, works the exact same way as Jim Crow, and the exact same ways that they discriminated against Jim Crow to keep them from making decisions or moving places that we wanted them to move is how we discriminate them now. That's why we get more black and brown people in prison. I'm trying to catch up on a couple it's all in previous chapters. That's straight from the book, and also the audio's on there. And it's the author reading her chapters. So, most ultimately return to prison, sometimes for the rest of their lives. Others released again, only to find themselves in precisely the same circumstances they occupied before, unable to cope with the stigma of prison life and their permanent pariah status. Reducing the amount of time people spend behind bars by eliminating harsh mandatory minimums would alleviate some of the unnecessary suffering caused by this system, but it will not disturb the closed circuit. Those labeled felons will continue to cycle in and out of prison, subject to perpetual surveillance by the police and unable to integrate into the mainstream society and economy. Unless the number of people who are labeled felons is dramatically reduced, and unless the laws and policies that kept ex-offenders marginalized from the mainstream society and economy are eliminated, the system will continue to create and maintain an enormous undercast. So, and then that is the end of this one. This is the guided reading on lesson 6. Let me see. I'm just going to go through some of the questions after our reading. Just kind of think on them, mill on them. And I'm going to say these ones again. Alexander describes consent searches, pretext stops, the volume approach, and the use of the drug courier profiles. What concerns does she raise in terms of the potential of these practices leading to widespread racial discrimination? So think about that. Like, you have access to the entire chapter if you want to listen to the entire chapter word for word from the author. I've got that on my blog. And then, but also, you have a link under this to the guided reading and the questions. And the guided reading, I just read to you what was on this if you didn't want to print it out or you were just in bed and wanted to listen because you had nothing else to do. So, Alexander raises the questions of why police who are responsible for solving violent crimes such as murder and rape would invest so much of their time focusing on non-violent low-level drug arrests instead. What answers does she give? And that one right there, think about how they incentivize that. Oh, listen, if you find a whole bunch of cocaine on that yacht is yours, Bubba. You know, like, I mean, and you know how, like, sometimes big man syndrome works, and you know, like, women in tech know how men, you know, have that. I'm sure that women in law enforcement, I mean, they play, you know, I've got women and men in law enforcement in my family, but, I mean, I'm sure that it's got the same kind of, and I bet they have quotas. Oh, they incentivized it. If it wasn't incentivized, they wouldn't do it, because it's hateful, and they'd see the error of their ways. What is the prison label? The author writes, reducing the amount of time people spend behind bars by eliminating harsh, mandatory minimums will alleviate some of the unnecessary suffering caused by the system, but it will not disturb the closed circuit. What do you think is her point? Some connector questions. The author illustrates the harshness of mandatory sentencing laws by giving a hypothetical, though realistic example of an 18-year-old man in California. Reread that scenario and then work with a partner, or you don't have to work with a partner, but kind of go back and like listen to this. And then can you think go back and think about that story and like reread it and then kind of mill it over in your head, and then like, do you know a friend, or do you know somebody who's been in a situation like that, or maybe you've heard a story where like it's like something just snowballed like that. In this guided reading, we learned that law enforcement agencies can keep for their own use the vast majority of cash and assets received in drug arrests. How might this authority lead to corruption of power? Can you think of other people in positions of authority, possibly with power over you, who have similar freedoms? Who do you think that is? And do you think that use like your situation and kind of think, if they're getting one up on me, what are they getting? You know, how does it compare to you? And then, what happened at Stratford High School in Goose Creek, South Carolina? Has anything like that happened in your school? If so, kind of mill it over in your head. Think about it. Did race figure into the incident at Stratford High? And have you ever seen an incident where race like that affect, where you saw an example like that? Kind of, you know, using empathy. I'm all about empathy. That's how I don't know. After reading that, sometimes, I don't know. I mean, I've read these and I've read the book, but sometimes reading things out loud, ooh, oh. There's some other books too, just wait till we get to those. But anyway, guided questions are on the website if you want to test them or go over them, or you're doing this lesson with your kids and you don't want to do the reading and you just want to have somebody else do it. I'm here for that. And then also, here's the guided reading if you just want to print it off. So there's also a fun kind of different exercise on there that I have provided the link to, and it's solely if you want to do it. And if you do it, tell me about it. Tell me about it on my blog. Just when discussing things with others, be kind, be nice, respectful. Thank you, and have a wonderful night.